Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. The Supreme Court has raised concerns about the Medical Termination of Pregnancy Act, which does not permit terminating pregnancies beyond 24 weeks, even in cases of minor victims of rape and incest. But it allows termination if there are serious abnormalities in the fetus. The court suggested that the lawmakers might think that handling the difficulties associated with a severely abnormal fetus could be more distressing for a pregnant person than experiencing rape. The bench of CJI D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra was dealing with the case of a minor who sought medical termination of pregnancy following a sexual assault. When her mother moved the Bombay High Court, the medical board gave an opinion declining termination, stating that there was no congenital abnormality diagnosed and gestational age of the fetus was between 27 to 28 weeks. This report, however, did not record the impact of the pregnancy on the physical and mental health of the minor girl. Initially, by setting aside the Bombay High Court order, the court had permitted the minor girl to undergo medical termination of pregnancy despite being in her 30th week. However, later, when the doctors outlined the inherent risks of terminating the pregnancy at advanced stage, she and her parents expressed changing views. This led to the court to hear the matter again. Ultimately, considering the wishes of the minor girl and her parents to deliver the child on the due date, as well as the minor girl's well-being, the earlier order permitting termination was recalled. The Supreme Court has reiterated the law point on Section 14, Clause 3 of the Juvenile Justice Care and Protection Act of 2015. The bench of Justices C.T. Ravi Kumar and Rajesh Bindal said that the provision which directs that authorities must decide within 3 months if a child under 16 years of age is capable of committing a serious crime or not is not in stone. It is not mandatory. Instead, it is more of a guideline or recommendation. The bench explained that because many people are involved in the initial investigation process, like the investigating officer and experts who give their opinions, and later in the proceedings before the board, any party could delay the process. So the time limit set in Section 14, Clause 3 cannot be considered as strict or mandatory. Unlike in cases of minor offences where there are consequences for not meeting the deadline, such consequences are not specified in this situation. Instead of interpreting the section of the Juvenile Justice Act strictly, the court construed the provision in a harmonious way to make it meaningful. In an important update, the Supreme Court has held that prescribing minimum qualifying marks for interview does not contravene the 2002 judgment of All India Judges case. The bench of Justices Rishikesh Roy and Prashant Kumar Mishra said so while deciding a case which originated from a writ petition concerning judicial appointments in Bihar and Gujarat, questioning the legality of the minimum marks needed in the interview stage of the both states' selection processes. The court, while delivering the judgment, explained that in the All India Judges case, the court was silent on the aspect of minimum cutoff marks for the interview, and that there is a reasonable and direct nexus with the object sought to be achieved, that is, to appoint well-rounded judicial officers by prescribing minimum qualifying marks in the viva voce, and it is well within the boundaries set in the All India Judges case to set minimum cutoff marks for the interview as part of the exam. The court has also flagged concerns about the absence of a designated authority by the high courts, which can be approached by candidates of judicial services examinations to seek clarification in case of any doubt. By placing reliance on the report of Vidhi Center for Legal Policy, the bench sought for establishment of the designated authority for a given recruitment process with clearly defined roles, functions and responsibilities so that candidates can approach it to seek clarification in case of any doubt. The Bombay High Court today upheld the Maharashtra government's notifications officially renaming the Aurangabad and Osmanabad city and revenue areas. In the year 2022, former Chief Minister Uddhav Thackeray's Mahavikas Aghadi government had decided on renaming of Aurangabad as Sambhaji Nagar and Osmanabad city as Dharashiv and revenue areas. However, the subsequent Shinde-Fadnavis government made a fresh decision on renaming and expanded the renaming of Aurangabad to Chhatrapati Sambhaji Nagar. The renaming of the revenue areas is governed by Section 4 of Maharashtra Land Revenue Code of 1966, which permits the state government to alter the limits of any revenue area or abolish any such revenue area and also to name it. Last year in February, the Union Ministry of Home Affairs approved the renaming. The state government then published a draft notification on the same day inviting objections from general public to renaming the revenue areas of Aurangabad and Osmanabad. Various pleas including PILs and writ petitions were filed challenging the renaming. It was stated that public sentiments were not considered while taking this decision and the state violated provisions of the Constitution of India. It was further alleged that the renaming is driven by political motives and fosters religious discord. The Maharashtra government, however, denied this contention and submitted that naming of a city on a personality held in high esteem by the entire state does not have a religious color. The division bench of Chief Justice Devendra Upadhyay and Justice Arif S. Doctor, while pronouncing the judgment today, dismissed the batch of pleas, stating that the notifications issued by the state government for renaming do not suffer from any illegality. The Delhi High Court has issued notice on a PIL moved by senior journalist Rajat Sharma, who is the chairman and editor-in-chief of India TV, against non-regulation of deepfake technology in the country. Deepfake technology is a sophisticated form of artificial intelligence that manipulates video or audio content to make it appear as though it is real. It can superimpose images or manipulate existing footage to create convincing but entirely fake content. You must have seen such videos making rounds on social media. For example, a fake video of Bollywood actor Aamir Khan seeking votes for Congress went viral recently. Similarly, an AI-generated video indicating Congress leader Rahul Gandhi to be swearing in as the Prime Minister of India was also circulated. The plea by Rajat Sharma states that deepfake technology poses significant threats to various aspects of society, including misinformation and disinformation campaigns, undermining integrity of public disclosure and democratic processes, and potential use in fraud and identity theft, etc. The PIL seeks a direction on the union government to identify and block public access to the applications, software platforms, and websites which enable creation of deepfakes. A division bench comprising Acting Chief Justice Manmohan and Justice Manmeet Preetham Singh Arora today remarked that this is a major problem and asked the central government if it was willing to act on the issue. The court has sought response of the union government through Ministry of Electronics and Information Technology. The Karnataka High Court has refused to reduce the sentence of 6 months of simple imprisonment which was imposed on an ambulance driver as he was convicted for driving in a rash and negligent manner. His actions caused an accident which led to the death of one person and injured 3 others. This was in the year 2011. He approached the High Court challenging the conviction order and prayed that he may be imposed with only fine as sentence. A single judge bench of Justice Umesh M. Adiga dismissed the revision petition. The court noted that if relief was granted, it would be a nominal punishment against the offence committed by him and would encourage negligent riders or drivers. In another update, the Tamil Nadu Congress Committee has moved the Madras High Court seeking directions to the Election Commission of India to call for explanation from Prime Minister Narendra Modi on his hate speeches and to take actions to curb false, derogatory statements and to restrain him from making further misleading and derogatory statements against the Congress election manifesto. Citing the recent speeches made by the Prime Minister, the plea says that the speech which targets sections of the minority is not only disrespectful but also shameful and treacherous as they fuel communal tensions and sow division among the people. The plea alleges that despite numerous complaints, the Election Commission has only sent a show cause notice, and such leniency shown by the ECI sends a wrong signal to the citizens and undermines the whole electoral process. And lastly, coming to the plea filed by former Delhi Deputy Chief Minister and Aam Aadmi Party leader Manish Sisodia, challenging the trial court orders which dismissed his second bail pleas in the both CBI and ED cases. The Delhi High Court today granted further time to the Enforcement Directorate and CBI to file their replies to the bail pleas. Justice Swarnakant Sharma listed the matter for hearing on coming Monday after Advocate Zohaib Hussain, appearing for the Enforcement Directorate, told the court that the Central Probe Agency wanted further 1 week's time to file its response. The request was opposed by Sisodia's counsel. You already know that Sisodia is presently under judicial custody in the money laundering and corruption cases related to the alleged excise policy scam. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.